Hi, Carol. If you're not too busy, can I have a quick word?
Hi, Martin. Come on in. It's nice to see you back from taking care of the new addition to the family. How's she doing?
Oh, she's well, thanks. 10 weeks old on Friday. But a full caseload and sleepless nights is definitely not a match made in heaven. I've got a new case on my desk that I need to do some research for, and I'm hoping you can point me in the right direction.
I'll certainly try. What's the case about?
The client is a Ms. Willoughby. She instructed us back in 2001 to assist her with the purchase of a property, Oakfield Cottage, but she's now in a dispute with her neighbours, Mr. and Mrs. Ashford, who originally owned her property and still own the adjacent land, Foxglove Farm. She got back in touch with the conveyancing department and they've transferred it over to us.
What's the nature of the dispute?
It's about a right of way. Ms. Willoughby alleges that she's been prevented from exercising some of her rights concerning her property in a way that she claims was previously agreed.
Let me guess. It's a dispute about the existence of an easement, am I right? Is it about whether or not someone has a right of way?
Not this time. There's no question that a right of way exists in this case.
Oh, well that makes a nice change.
It does. This is because when Mr. and Mrs. Ashford sold the property back in 1989 to the people our client eventually bought it from, a clause was drafted into the conveyance deeds granting a right of way over the Ashfords' land.
Oh, I see. So what's the problem then?
Well, the Ashfords have recently erected a gated fence between the two pieces of land. They say this has been necessary because there were a few incidents last year when some of their cattle were able to get off their own land and went walkabout in the nearby woods.
Well, that seems reasonable enough.
Well, yes, but the thing is, there's already a gated fence between the properties, which was put there when the Ashfords first sold Oakfield Cottage in 1989. The new gate is about 150 yards from the old one, nearer to the Ashfords' property.
And Ms. Willoughby's arguing this is excessive.
Exactly. And the thing is, I wouldn't like to bet on which way the dice would fall if we were to end up in court. I know that any interference with an easement for a right-of-way has to be a substantial interference in order to be actionable in court, but I don't know if the construction of this second gate would fall within that definition.
Well, there are always cases in court where claimants argue that the erection of fences or gates have restricted the use of their right-of-way. And you're right, the situation you've got isn't clear-cut. Whilst there is a precedent case from 1914, Petty versus Parsons, which states that a gate won't necessarily amount to a substantial interference in itself, each case will depend on its own facts.
Yeah, I had a horrible feeling that would be the case. Do you know of any cases that might work in our client's favour?
There is one worth considering, which may be useful or not, depending on the facts of Miss Willoughby's case. It's called Kingsgate Development Projects Limited versus Jordan, and it concerns a dispute which arose in April 2016 between neighbours. The case was heard in the High Court and the judgment was handed down in March this year.
I'm all ears.
In this case, the defendants, Mr and Mrs Jordan, purchased a property, Riverdown, in July 2012. This property was next to Kingsgate Farms, owned by the claimants, Kingsgate. There was an express easement giving Kingsgate a right of way over part of Mr and Mrs Jordan's land.
And let me guess, there was a gate on the property restricting Kingsgate's right of way.
Not just one. When Mr and Mrs Jordan purchased Riverdown, there were already 2 gates on the part of the land subject to the easement, and they then added a third.
Oh, really? So the claimants were in an even worse position than Ms Willoughby. What happened?
Well, on reading the judgment, it's clear that the judge had considered both the operation of the gates and the proximity of the gates to each other to reach a decision.
And what was his conclusion?
The operation of the gates turned out not to be a contributory factor in this case. This was because one of the gates, which was named gate number 1, unlocked and opened easily by the push of a button, which the judge concluded was therefore easier to operate than a manual gate. And the other gate, gate number 3, was always kept unlocked.
And what about gate number 2?
Well, the claimants were successful when it came to gate number 2, which was situated between gates 1 and 3 and was the last gate to be built.
Oh, good. And was this because this gate was more difficult to open and close?
No, the judge did not need to consider this. He held that as the installation of this gate meant that there were 3 gates within 100 metres of each other, this was sufficient for gate number 2 to amount to a substantial interference. He ordered the Jordans to remove gate 2 and pay the defendant some nominal damages.
I've got an appointment with Ms Willoughby next week, so I'll get more details then about how the gates operate and their proximity to each other, and we'll take it from there.
Yeah, good idea. The only thing I would say, though, is that you still never know which way these cases are going to go. I would try and encourage Miss Willoughby to try mediation with the Ashfords if necessary.
Oh, I absolutely agree. Thanks so much for your help.